You don't own this driveway anymore, Michael. The HOA does. Karen said that at 6:15 in the morning, standing beside her white sub with a violation notice in one hand and a smile on her face. She was talking about the concrete my father helped me pour. The driveway my work truck used every morning to keep my bills paid. I didn't argue. The doorbell camera was recording. The plat map was in my hand, and the tow driver was about to ask for the one document. That would make Karen's entire collapse. To understand why I didn't yell that morning, you need to understand exactly what I saw when the garage door opened. The morning Karen blocked my driveway, I had coffee in one hand and my work keys in the other. It was 6:15, and Maple Bend Court looked half asleep. My garage door rolled up, and the yellow light over my workbench fell across the hood of my truck. I had a heater call at 7. Mr. Whitaker, an old widower across town, had called before sunrise because his furnace had quit. The job was worth $475. More than that, it was work that kept me moving after Ellen died. People needed help. I knew how to fix things, so I kept showing up. Except that morning I couldn't leave. Karen Hargrove's white SUV was parked sideways across my driveway. Not crooked. Not too close to the curb. Sideways. Front bumper near my hedge, back bumper near the mailbox, blocking the stretch from my garage to the street. And Karen was standing beside it like she had planted a flag. She wore a light blue cardigan and dark sunglasses, even though the sun wasn't up. In one hand she held a paper with the Oak Hollow Estates logo at the top. Across the page, in red letters, it said Final Enforcement Notice. The second thing I noticed was the fine amount. $725. $250 for the original commercial vehicle violation. $300 for continuing noncompliance. And $175 in administrative recovery fees. I had checked that phrase the night before. It did not appear in the bylaws. Morning, Michael, she said. Well, I'm glad you're finally available. I looked at the SUV, then at my truck inside the garage with the ladder on top and my toolboxes strapped down. What are you doing, Linda? She lifted the paper like it was a court order. Enforcing community standards. Your commercial vehicle is still in violation, and the board has authorized action. She said board the way some people say law. I felt heat come up the back of my neck. Not just because of the money. It was the driveway. That concrete was not just a place to park. My father helped me pour it in 2006, the summer after Ellen, and I bought the house. Dad was 72 then, still too stubborn to sit in the shade. Ellen sat on the porch with iced tea, laughing at both of us. Years later, that same driveway carried her home from chemo appointments. It carried groceries, snow shovels, Christmas trees, and the routines that make a house feel like yours. Now Karen was standing on it, telling me the HOA had control. You reblocking my driveway, I said. No, she said. You created this situation by refusing to comply. Then she leaned toward me and lowered her voice. You don't own this driveway anymore, Michael. Not while enforcement is active. That was what she wanted me to react to. Across the street, Mrs. Delgado's curtains moved. 2 houses down, a garage light came on. Karen had picked the time on purpose. Early enough to trap me, late enough for neighbors to see. She wanted me shouting while she stood there with her paper. I didn't give her one. In my jacket was a folded county plat map. I had printed it from the Recorder's website at 11:38 the night before after reading the meeting minutes. Lot 42. My lot. My driveway. The black boundary line ran clean from the garage apron to the sidewalk. No easement. No emergency access strip. No HOA access lane. No recorded instrument giving Oak Hollow Estates the right to block it, tow from it, or call it theirs. A notice can threaten. A plat map can prove. Karen only had the first one. My phone buzzed. Mr. Whitaker again. I let it ring. Karen noticed. You should have handled this before it affected your business. That almost got me. Not the insult. The satisfaction in her voice. She knew I needed that truck. She knew I was still trying to keep my little repair business alive after Ellen died. Then she tapped her phone and put it on speaker. Yes, this is Linda Hargrove, HOA president for Oak Hollow Estates. I need the tow truck at Maple Bend Court now. The homeowner is refusing to comply, and his commercial truck is blocking association access. There it was. The lie, spoken clearly, with my doorbell camera recording. My truck was not blocking association access. My truck was inside my garage. Her SUV was the only vehicle blocking anything. I could have unfolded every page right there. The plat map, the CCRS, the management company email, the meeting minutes showing no vote, no motion, no approval for towing, and not one word about my driveway. But if I corrected her too soon, she would call it confusion. She would smile at the next board meeting and say Michael overreacted. So I let her keep talking. Yes, she said into the phone. The board approved enforcement. That sentence mattered. Because now it was not only on my camera. It was on speaker, in front of my neighbors, and in the tow company's call record. 9 minutes later, the tow truck turned onto Maple Bend Court. Karen stepped away from her SUV like the hard part was over. The driver climbed down, looked at my garage, looked at my truck, then looked at Karen's SUV, blocking the driveway. He did not reach for his hooks. He reached for a clipboard. "Ma'am," he said, "before I touch any vehicle, I need written authorization from the property owner and proof the HOA has towing authority on this driveway." Karen reached into her folder like she had been waiting for that question. But what she pulled out was not authorization. It was the same notice I had checked against the bylaws the night before. For the first time that morning, Karen stopped smiling. And it would not be the last. But Karen did not wake up that morning and decide to block my driveway out of nowhere. She had been building toward that moment for 3 weeks. One notice, one fine, and one lie at a time. 3 weeks before Karen put her SUV across my driveway, the whole thing started with a paper taped to my front door. I found it on a Tuesday afternoon after a heater repair. My hands still smelled like metal dust and electrical tape. I had coffee in the cup holder and the tired peace that comes after fixing something for somebody who needed it. Under the clip on my door was one sheet. Oak Hollow Estates Homeowners Association. Notice of violation. Under that, in bold type, it said, "Commercial vehicle visible from street." Below it was a photo of my truck. My 2012 Ford F-250. Parked in my driveway. The same place it had been parked for almost 18 years. It had a ladder rack, 2 side boxes, and my name on the door in faded blue letters, Turner Heating Repair. The back bumper still had the dent from the winter Ellen backed into the trash bin, and told me the bin jumped out at her. I never fixed that dent. After she died, some marks became part of the house. Part of the marriage. Part of how you remember somebody when the rooms get too quiet. That truck paid the mortgage after the medical bills took most of what we had saved. It took me to furnace calls, leaking water heaters, and the little jobs bigger companies did not want. It was not a hobby vehicle. It was how I kept going. And now somebody had photographed it from the street and decided it was a violation. At the bottom of the notice was Karen Hargrove's signature. Linda Hargrove, HOA president. Community Standards Enforcement. Karen had become president 8 months earlier. The old president had been boring in the best possible way. Karen was different. Karen liked phrases like community standards, property values, uniform appearance, and resident responsibility. She said them at meetings with her chin lifted, like each phrase was a little badge pinned to her cardigan. The first time I noticed her, she told Dale, a retired firefighter 2 houses down, that his American flag bracket was visually inconsistent because it angled too far toward the sidewalk. Dale laughed because he thought she was joking. Karen did not laugh. Still, when I got that first notice, I tried to be reasonable. Went inside, washed my hands, and pulled the HOA binder from the bottom drawer of my desk. Ellen had labeled it years ago with masking tape. House stuff taxes, warranties, HOA nonsense. I smiled when I saw the word nonsense. Then I opened the CCRS. The truck rule was section 7.4. I read it once. Then I read it again, slower. No commercial vehicle, trailer, camper, or recreational vehicle shall be parked overnight on any street or common area, except with prior written approval of the association. Street or common area. Not driveway. Not garage. Not private lot. A HOA rule has a boundary. Karen was trying to stretch it across my driveway. I printed the notice. I printed section 7.4. I highlighted the words street and common area in yellow. Then I printed a photo of my truck from Karen's angle. I wrote the date on all 3 pages and put them in a manila folder. On the tab, I wrote, Oak Hollow truck. Not because I expected a war. Because Ellen used to say I had 2 settings, fix it now or document it first. That evening, I wrote Karen a short email. Linda, I received the notice regarding my truck. Section 7.4 appears to apply to streets and common areas, not private driveways. My truck is parked on my private driveway. Please send the specific rules section you believe applies. Thank you. Michael Turner. Lot 42. No anger. No sarcasm. No extra words. Karen replied 12 minutes later. Michael, the board has discussed this matter. Your vehicle is commercial in nature and negatively affects the appearance of the neighborhood. Please comply within 48 hours to avoid fines. Linda Hargrove, HOA President. That was the first time she used the phrase "the board has discussed this." It sounded harmless enough. It was not. The next morning, I walked over to see Dale. You get one of Karen's love letters? He asked. I held up the notice. He shook his head. She got me for the flag bracket. I asked her to show me the rule. She sent me a photo of my own porch and a paragraph about community harmony. Did you keep it? Email envelope, picture, all of it, Dale said. If somebody writes nonsense down, don't throw it away. That mattered. One notice could be a mistake. The pattern was something else. A few days later, the fine arrived by certified mail. $250. The letter said failure to pay could result in daily charges, collection costs, and enforcement action. It had no meeting date, no vote count, no appeal form, and no citation beyond section 7.4. So I requested the meeting minutes. I sent the request to the management company, not Karen. Certified mail and email. I asked for the last 3 board meetings, any written policy about commercial vehicles on private driveways, and any record of a vote regarding enforcement against Lot 42. Then I waited. Karen did not. She came to my door 2 evenings later at 78 while I was heating soup. The porch camera caught her, walking up with a clipboard tucked against her side. When I opened the door, she looked past me into the hallway. Michael, this can be very simple, she said. Move the truck, pay the fine, and we can all move forward. We? The community. I read the rule, I said. It does not say what you saying it says. Her expression changed, but only for a second. You not an attorney. No, I said. Am I a homeowner? She smiled like that was a smaller thing. Then you should understand that owning a home in an HOA means accepting limits. I thought about my father on that driveway with a shovel in his hands. I thought about Ellen writing HOA nonsense because she knew someday I would need the laugh. I accept the limits I agreed to, I said. Not the ones you make up. For the first time, Karen's voice went cold. You have 48 hours, Michael. After that, I want to be responsible for what enforcement looks like. Then she turned and walked away. I closed the door and stood there in the quiet kitchen, the soup beginning to bubble behind me. That was when I stopped thinking of it as a misunderstanding. I downloaded the porch video, saved Karen S. email, scanned the certified letter, and placed Dale S. letter behind mine in the folder. Not because I wanted to fight. Because somewhere between the fake deadline and the way she looked into my house, like she owned the air inside it, I understood what Karen was really after. It was never just the truck. It was control. And 2 days later, the management company sent me the meeting minutes that proved she had lied about where that control came from. The meeting minutes arrived on a Thursday afternoon. I was at the kitchen table with iced tea and the Oak Hollow truck folder open beside my plate. Some papers. Stop feeling like clutter when they are the only thing standing between you and someone else's version of the truth. The email came from the management company, not Karen. 3 attachments. August minutes. September minutes. October special session. Karen had used 2 phrases with me. First, she said the board had discussed my truck. Then she said the board had authorized enforcement. Those are not the same thing. Discussed is fog. Authorized leaves a record. I printed the minutes and read them with a yellow highlighter. October listed pool gate repairs, landscaping bids, late dues, and a wreath budget. No truck. No lot 42. No motion. No second. No vote. No towing policy. At the bottom of the management company S email was one sentence. Management has no record of a board vote authorizing towing, driveway enforcement, or any special action concerning lot 42. I printed that page twice. One went in a clear sleeve. I wrote on the tab, official record. That night, I looked at Ellen.'s blue coffee mug on the shelf by the sink. It still had a chip near the handle. I had not used it since she died. Some things stay because moving them feels like losing them twice. Quiet means you can hear the lie clearly. The next morning, Karen sent another notice. Second and final demand before enforcement. The balance had gone from $725 to $875. A new line had appeared, compliance review fee. I checked the bylaws again. No such fee. At 8:32, she posted in the Oak Hollow Facebook group. Commercial vehicles reduce neighborhood character. Enforcement actions will continue against residents who believe rules do not apply to them. She did not use my name. She did not need to. Dale texted first. Print it before she deletes it. So I did. Screenshot. Print out. Date. Time. Folder. By Monday, I drove to the county recorder's office. A clerk named Marcia helped me at the public terminal. I asked for the recorded plat for Oak Hollow Estates, the deed for Lot 42, and any recorded easements affecting my driveway. Marcia looked over her glasses. "Ho, dispute?" "Yes, ma am." She sighed. "We get those." The records were plain. Lot 42 ran from the rear fence to the front sidewalk. The utility easement was along the back 6 feet, nowhere near the driveway. There was no access easement, no common area strip, no HOA control lane, and no recorded instrument giving the association authority over my driveway. Marcia stamped the certified copies. They went into the folder too. People think legal fights start in courtrooms. Most start under fluorescent lights, with a clerk, a printer, and one tired homeowner asking for one more page. Then Karen crossed a line that had nothing to do with paperwork. Tuesday afternoon, I was replacing a thermostat for Mrs. Blake when my business phone rang. I let it go to voicemail because I was on a ladder. A few minutes later, Mrs. Blake looked at me from the hallway. "Michael," she said carefully, "is everything all right with your business?" I climbed down and checked my phone. The voicemail was from Karen. "This is Linda Hargrove, president of Oak Hollow Estates HOA. Mr. Turner is currently operating a non-compliant commercial vehicle from a restricted residential property. Until this enforcement matter is resolved, residents and vendors should be aware that his business use of the property is under review." She had called the number painted on my truck. Not my home. My business. She had tried to carry the HOA dispute into the one thing I still had to earn a living with. I stood in Mrs. Blake's hallway, holding that phone, feeling something colder than anger. The feeling you get when someone shows you they are willing to reach past the argument and touch your livelihood. Mrs. Blake softened. "My late husband was on a condo board," she said. "Save that message." I did. I downloaded the voicemail, emailed it to myself, wrote a transcript, and added a new tab. Tab 8, Business Interference. That same week, I called the towing company Karen liked to use. I asked what they required before towing from a private driveway inside an HOA. The dispatcher was careful. Authorization from the property owner or authorized property manager, proof the location is covered by the tow agreement, and written documentation from the association. Does a violation notice count? No, sir. Not by itself. She emailed me their written policy 15 minutes later. I printed it. Then I paid for a 1-hour consultation with a real estate attorney named Denise Mallory. I brought the folder. She read in silence. The notice. Section 7.4. Karen's emails. The minutes. The certified plat. The easement index. The towing policy. The voicemail transcript. Then she looked up. "The rule says street and common area," she said. "Your driveway is neither. I also see no board vote, no towing authority, and now a voicemail that may create a separate problem for her. What should I do?" Do not argue in the street. Keep everything in writing. Send a formal demand to the board and management company. Ask for the rule, the vote, the towing authority, the vendor contract, and the appeal procedure. Then she tapped Karen's email. "This is no longer just a truck dispute," Denise said. "If she orders a tow after receiving this record, she is acting against notice." Those words stayed with me. Against notice. Karen could not later say nobody told her. So I sent the demand by certified mail and email. Karen replied in 26 minutes. "Your continued refusal to comply is disappointing. If the vehicle remains visible from the street, enforcement will proceed. I will personally make sure this is resolved." Personally. That was the word. By Friday evening, the management company answered. Management has advised Mrs. Hargrove that no towing action may be taken from a private driveway without board authorization, owner consent where required, and verification that the property is subject to the association's towing policy. Management has no record of such authorization regarding Lot 42. I printed it and placed it in a new tab. Tab 11, Management Confirmation. At 9:46 that night, Karen sent her last email before the morning she blocked my driveway. "Your failure to comply has left the association no choice. Tomorrow morning, enforcement will occur at your property. This matter ends now." I sat at the kitchen table with that email in front of me and Ellen.'s mug on the shelf across the room. For the first time in weeks, I felt calm. Karen had taken a private grudge, wrapped it in HOA language, reached into my business, received a formal record, and wrote it anyway. I printed the email. I wrote the time on top. Then I turned off the kitchen light. The next morning, her white SUV was across my driveway. The tow driver's name was around. I remember that because he introduced himself before he touched anything. He stepped out, pulled on his gloves, and looked at my garage first. Then he looked at my truck sitting inside it. Then he looked at Karen's white SUV parked sideways across my driveway like a barricade. He did not hurry. That bothered Karen. People like Karen depend on motion. A flashing light, a tow hook, a man walking fast enough to make everyone feel the decision has already been made. Aaron did not give her that. "Ma'am," he said. "Who called this in?" "I did," Karen said. "Linda Hargrove, HOA president." "And what vehicle am I here for?" "That truck," she said, pointing into my garage. "It's in violation." Aaron looked again. "With S in the garage." "It is visible from the street when the garage is open," Karen said. "The association has authority to remove commercial vehicles." She said it, like she had practiced in the mirror. Aaron looked at me. "Sir, is this your property?" "Yes," I said. "Lot 42. Karen cut in. "This is not his decision. This is HOA enforcement." Aaron raised one hand, calm but firm. "Before I touch any vehicle, I need written authorization from the property owner or valid documentation showing the HOA has towing authority at this exact location." Karen opened her folder and pulled out the final enforcement notice. She handed it to him like a winning card. Aaron read it. "This is a fine notice," he said. "It is an enforcement notice," Karen snapped. "It does not authorize a tow." I reached into my jacket and unfolded the county plat map. My hands were steady, which surprised me. Inside, I was thinking about Mr. Whitaker's cold house, Ellen's dented bumper, and my father smoothing wet concrete in July heat. I was thinking about how many ordinary mornings people like Karen steal from people who are just trying to get to work. "Aaron," I said, "this is the certified plat for Lot 42. My driveway is inside my private lot. No access easement. No common area strip." Then I handed him the management company email. They also confirmed there was no board vote authorizing towing or driveway enforcement. Aaron read both pages slowly. Karen laughed once, sharp and fake. "He says twisting this. He has been difficult for weeks." Aaron looked at her SUV. "Ma'am, right now the only vehicle blocking access is yours." That sentence landed harder than shouting. Mrs. Delgado was on her porch by then. Dale had come out in a sweatshirt. Two neighbors stood near the sidewalk, pretending to check trash cans. Karen stepped closer to Aaron. "Are you refusing an HOA order?" "I'm refusing an unauthorized tow," he said. "And I need you to move your vehicle." Then he called dispatch. "Cancel tow on the Ford truck," he said. "No valid authorization provided. Vehicle is on private residential property. Reporting party SUV is blocking the driveway." Before he left, Aaron filled out a one-page refusal report on his clipboard. He wrote the reason in plain words. "No valid tow authorization, private driveway, reporting party blocking access." He tore off the customer copy and handed it to me. Karen watched that paper change hands, and her face went tight. "You set this up," she said. "No," I said. "You drove here." For a moment, nobody spoke. Then Mrs. Delgado called from her porch. "Move your car, Linda." Karen moved the SUV 9 minutes later. "Not right away. People like Karen need time to pretend they are choosing what they have been forced to do." When the driveway was clear, I called Mr. Whitaker and apologized. He said, "Take your time, son. I foft got blankets." That almost broke me more than Karen had. I made the heater call late. I fixed the furnace. Before I left, Mr. Whitaker handed me coffee in a paper cup. Some people make themselves important by making other people's lives harder, he said. I drove home with that sentence in my head. That evening, the HOA board meeting was held in the clubhouse. Karen arrived early. I arrived with my folder. Not loose pages. Tabs. Notice. Section 7.4. Emails. Certified plat. Easement index. Board minutes. Management confirmation. Towing policy. Voicemail transcript. Doorbell footage log. Aaron's refusal report. Dale sat behind me. Mrs. Delgado sat beside him with her flower pot notice in her purse. The management company's representative, Mr. Larkin, was on speakerphone. That mattered. Karen could talk over neighbors. It was harder to talk over the company paid to keep the records. Karen called the meeting to order with a tight smile. Before we begin, she said, I want to address the ongoing issue of non-compliance and hostility directed at this board. I raised my hand. She ignored it. She talked about community standards, property values, and consistent enforcement. She said my truck had created weeks of disruption. She said she had acted under board authority. That was the third time she said it. So I stood. Not fast. Not angry. Just stood. Linda, I said, please identify the meeting where the board voted to authorize towing from my driveway. The room got quiet. This is not a courtroom, Michael. No, I said. What's a board meeting? So the minutes should matter. I handed copies to each board member. August, September, October. No motion. No second. No vote. No towing authorization for Lot 42. Karen shook her head. The board discussed enforcement strategy. Discussed is not authorized. Mr. Larkin's voice came through the speakerphone. Management has no record of a towing authorization for Lot 42. Karen turned toward the phone. That is not the full context. Beth Rowland, the treasurer, looked down at the email in front of her. Linda, Beth said, did you order a tow after management told you not to take towing action without authorization? Karen's mouth opened. Nothing came out. I plugged my laptop into the clubhouse screen and played the doorbell video. Karen SUV across my driveway. Karen saying my truck was blocking association access. Karen saying the board approved enforcement. Then Aaron S. voice. Ma'am, before I touch any vehicle, I need written authorization. He paused on Karen holding the notice. This is what she gave the tow driver, I said. A fine notice. Not authorization. Then I read Aaron's refusal report. No valid tow authorization. Private residential property. Reporting party blocking access. Dale stood behind me. You didn't vote on my flag notice either, he said. Mrs. Delgado lifted her envelope. Or my flower pots. That was the moment Karen lost the room. Not because I yelled. Because the paper finally said out loud what everyone had been too tired to prove. Karen had not been enforcing rules. She had been inventing power. And for the first time since she became HOA president, the whole room understood the difference. The room stayed quiet for a long time. That is what I remember most. Not Karen S. face. Not the video frozen on the clubhouse screen. The quiet. For weeks, Karen had filled every space with her voice. Community standards. Property values. Board authority. Enforcement. But once the papers were on the table, once Aaron's refusal report had been read aloud, there was nothing left for her voice to hide behind. Beth Rowland, the treasurer, took off her glasses and set them beside the printed minutes. "Linda," she said, "I am making a motion for no confidence and immediate suspension of your enforcement authority, pending a full review." Karen stared at her. "You cannot do that." Alan Pierce, the vice president, opened the bylaws. "We can," he said. "And after tonight, we have to." The motion passed 3-1. Karen voted no. It was the first official vote about my truck that had ever actually happened. Mr. Larkin from management stayed on speakerphone while the board cleaned up what Karen had made dirty. My fines were suspended. The towing threat was withdrawn. Management was ordered to send written confirmation the next business day. I did not clap. I did not smile at Karen. I just sat there with my hands on the folder and let myself breathe. The email came the next morning at 9:14. "Mr. Turner, Oak Hollow Estates HOA hereby withdraws all violation notices and fines issued regarding the commercial vehicle complaint against Lot 42. Management confirms that no towing authorization existed, no driveway enforcement authority was approved by the board, and Section 7.4 does not prohibit a homeowner from parking a work vehicle on a private driveway." I printed it. Of course I did. I put it in the last tab. Final confirmation. The following week, Beth read the correction into the official minutes. She said my name clearly. She said Lot 42 was never under towing authority. She said the board had no record of a valid vote against my truck. She said the violation had been issued without proper legal basis. That mattered more than I expected. Because a man can ignore gossip. He can swallow insult. He can keep working through embarrassment. But when somebody uses an official letterhead to make you look guilty, the correction needs to be official too. The board voted to attach the final resolution to the permanent HOA records, along with Aaron S. refusal report, the management company letter, and the corrected minutes. The record would not forget. Karen resigned before the audit finished. Her email said she was stepping away because of unfair personal attacks. Nobody read it aloud. Nobody needed to. The next meeting, Karen sat in the second row, not at the board table. Management revoked her access to the violation portal that same day. She was barred from serving on any enforcement committee for 3 years. The board also voted that no single board member could issue fines, contact tow companies, or represent personal action as board-approved enforcement. Dale leaned over and whispered, "That one should have been obvious." For the first time in weeks, I laughed. The audit took 6 weeks. When it was done, 23 violation notices were corrected. 11 fines were refunded. 4 homeowners received apology letters. The board repaid my $475 for the missed service call, reimbursed the $14.50 I spent on county records, and removed every late fee attached to the truck violation. They also paid Denise Mallory to review the new enforcement policy. Every violation now had to cite the exact bylaw section. Every fine required a board vote recorded in the minutes. Every homeowner had a written appeal period. No towing could be requested without management approval, board authorization, and proof that the vehicle was on property covered by the towing agreement. And no board member could personally block a driveway. Dale raised his hand and said, "Please underline that." People laughed, not because it was funny, but because the room finally felt safe enough to laugh again. By spring, Oak Hollow felt different. Not perfect. HOAs never become perfect. But quieter. Less afraid. Mrs. Delgado put 6 clay pots on her porch. Dale adjusted his flag bracket exactly the way Karen had hated it. And I kept parking my truck in my driveway. Most mornings, I still left before 7. The garage door still groaned. The ladder rack still rattled. The dent in the back bumper was still there. One Sunday, I washed the truck with the old green bucket Ellen bought because she said the blue one looked depressing. I rinsed soap off the door, where my name was painted, and watched the water run down the concrete my father helped me pour. Nothing dramatic happened. No shouting. No SUV. No clipboard. Just my house, my truck, my driveway, and the kind of quiet you do not appreciate until somebody tries to take it from you. I still keep the oak hollow truck folder in the bottom drawer of my desk. I do not look at it often, but I know it is there. Bullies count on exhaustion. Fake authority counts on people being too tired to ask for proof. But paper has a memory. Cameras have a memory. Minutes have a memory. When you keep your receipts, the truth does not have to shout. So if an HOA Karen ever threatens your truck, your driveway, your garage, your fence, or the home your family built, do not start by yelling. Start with the record. Ask for the rule. Ask for the vote. Ask for the authority. Save the email. Print the notice. Keep the voicemail. Because fake power collapses when real evidence walks into the room. And if you have ever dealt with an HOA Karen, tell me your story in the comments. Would you fight back right away, or wait until the paperwork was perfect?